This is an interview with Lisa Krisher. Krisher, is that right?
Yes.
On July 18th at the offices of Georgia Legal Service Program, and it's in conjunction with the 30th anniversary Oral History Project of Georgia Legal Services. So Lisa, I always ask people sort of what is the trajectory that took you from wherever to get to Georgia Legal Services? How did you get here?
Well, I went to law school to be a poverty lawyer, and I went to Antioch in Washington, D.C. And so while I was there, I had some clinical instructors who worked in legal services programs in the South, and I had come from South Carolina, so I was looking to come back south. And we had a clinical fellow there, Jack Salmon, who is a professor now at Mercer, who was really pushing Georgia. And so Georgia Legal Services had a really good reputation, and so I was recruited to come here, and I've been here ever since.
What prompted you to be a poverty lawyer in the first place?
I think being in Charleston as a person who moved there from another place and experiencing the racial issues, poverty issues, and not being from Charleston, I think I appreciated the injustices that I saw perhaps more than if I had always lived in that place.
Your family moved to Charleston when you were how old?
In the 9th grade.
Okay. From?
Pittsburgh.
So culture shock.
Yes.
Or culture.
Yes.
Opening your eyes.
Yes, right.
And you'd gone to college where?
Clemson University.
Okay. And went from Clemson to Antioch. That must have been something
Yes.
of a culture shock as well.
Yes. Oh, definitely. When I arrived at Antioch, there weren't very many Southerners there, and I think that we were kind of ostracized at first. It was much more dominated by people from the Northeast, and having lived in the Northeast, I was like, it doesn't matter where you're from, but it was a really interesting experience. We had an incredible class of people and lots of different backgrounds, experiences, and so it gave law school a whole other dimension. Besides learning the law, we were learning about people and dealing with issues and solving problems. And that really prepared me to be a lawyer in Georgia.
Now, of course, Antioch Law School is, of course, associated with the Cons, who are
Yes.
associated with the origins of legal services.
Yes,
too.
yes, they were the deans when I was there.
There must have been like this high priority given to this kind of...
Definitely. They had incredible ideas and ability to put things together, and made you think about how to deliver legal services. One of our courses was legal delivery systems, something that we continue to deal with now, but that was something we were looking at even in law school.
So you arrived in Augusta when?
In August of 1978.
Again, people have referred to those as the kind of the golden years of Georgia Legal Services. So maybe describe sort of the ambience and the atmosphere when you arrived in Augusta at that point.
Well, at the time, our office was involved with a Burke County voting rights case, so that was in the background. Also, there were other attorneys who started at the same time that I did, and we were going to be opening an office in Waynesboro, which is Burke County seat, about 35 miles south of Augusta. And so it was an exciting time of hiring more staff, looking at how to deliver services there, addressing needs, and that was very exciting because it had a lot of opportunities for new attorneys to take on challenges, and that was part of the reason that I wanted to go to Augusta.
Oh, you wanted to go to Augusta per se?
Yes. Yes. Each one of the offices, I think even now, has a kind of, not necessarily a persona, but a practice area that they focus on, and the Augusta office had a tradition of working in the federal courts and addressing complex issues, and I'd had that opportunity in law school, and I wanted to continue that.
So had the Burke County voting rights case, you said, had already been initiated
yes,
in the late 70s?
Yes. It was tried during the early time that I was there. And there were other big cases that were addressed. We had the Reidsville prison case, Williams versus Butts, the farmer's home case came out of Augusta. We did a number of jail and other prison cases, public benefits, class actions. There were lots of things for as I said, for new lawyers to volunteer on and work on and get the opportunity to have experience and make a contribution to, even if it was shepherdizing cases.
Who else were on staff in Augusta?
The managing attorney when I started was Joe Baird.
B.A.
IRD, right? He's a hearing officer now for the state. Bob Cullen was the senior staff attorney and a person who was involved with all the significant litigation that we did. Martha Miller was an attorney, and another attorney who had started around the time that Martha did was Ben Allen. He's now a state representative from Augusta. And then we had new attorneys who came in at the same time that I did. There were three of us.
Sounds like a pretty exciting place, right?
There was lots going on, lots of work, and in those days, because we were new, and even the people with experience were relatively inexperienced by standards today, everyone worked all the time, and you always went back to work after dinner, and always worked at least one day of the weekend, if not both days, because there was just so much to do, and it's the times too, I think.
I'm trying to get into sort of the atmosphere of those 70s era.
I think people were, the opportunities were great. There were lots of injustices, and there were all kinds of due process issues, and going to Antioch, that's what we learned. So it's very easy to take that and look at a set of facts and put together a lawsuit and win. What's disturbing to me is that now, after all those years, we're seeing those due process issues back, and with almost a total lack of due process in some governmental programs. That's shocking, considering that the law has been clearly established by the Supreme Court for over 30 years.
Give us, for instance, what kind of areas of due process? I mean, what are you talking about more specifically?
Well, right now there are issues with the kind of notices that people get with public benefits. They get them late. They're written in a way that people can't understand them. It's not meaningful notice. The standard is, notice and meaningful notice that someone could understand, and that's not happening in a variety of contexts. So we're working on challenges, both individual ones and looking at a broader attack on several issues.
What kind of due process things were you involved with, say, in the late 70s, early 80s in the Augusta office?
We had several big housing cases. One of the first cases that I filed myself was challenging the leases at the rural housing rental program, and the judge struck down all the leases that the projects used across the state because they had invalid lease terms. And it was very exciting because it arose out of a case with two clients, and by looking at the regulations and the leases, we realized there were all sorts of other problems. And I was actually quite surprised when the judge not only granted the remedy for my clients, but also decided that all the leases were invalid and ordered the Farmers Home Administration to rewrite the leases for the entire state.
Can you take us more into the particulars and the evolution of that particular case?
Well, that case dealt with an eviction of two tenants in a rural county outside of Augusta, and they came to us because they'd received a letter from the housing development saying they were going to have to leave because they violated their leases. And so I was concerned about trying to litigate that in the state court, because it's often difficult to convince, and especially back then, it was very difficult to convince a state court judge that the federal regulations applied. And so we worked on this. I had help from our housing specialists, and we put together a lawsuit to file in federal court and seek a temporary restraining order so that the tenants would not be evicted while we litigated the legality of the leases and the notices. And we were successful in convincing the parties to agree to not take action while we did litigate it. And then we were successful on most of the case. And the best part was getting the clients to be able to stay in the housing.
So the first step was getting it placed in federal court.
Yes, yes. Because rural housing, well, then the Farmers Home Administration is a federal program and somewhat complex. At least at that point, that was new. Some other cases had addressed in Georgia whether the federal public housing regulations, for example, applied in state courts, and of course the Georgia court said yes, but the rental housing of the Farmers Home Administration was a little less well known, and so we were concerned that if we had to litigate that it would be difficult and that they could lose, even though we had a good case. So, you always look at choice of forum when you're attempting to file an affirmative lawsuit.
And almost always federal court would be the preferred.
Well, at least at that time. The federal courts were much more experienced at looking at federal due process. In more recent years, the Georgia courts have been much more hospitable to those issues, and also looking at the state constitution, which is quite favorable on many issues to our clients.
What about the balance between kind of getting these big cases that are appellate cases or federal cases, constitutional kinds of cases even, and the daily work of providing legal services to the poor? Can you speak to that in the Augusta office first, and then maybe kind of talk about that more generally?
Well, that's always a challenge in legal services because we can't do every case there is. But one of the things that I think is always important for you to recognize is that it may be that bringing the big case is the way to address the greatest number of people. And so sometimes you can reconcile the demands for services with what you can do with, okay, how are you going to maximize that? And when we could do class actions, filing a class action was most often the easiest way to address a broad group of people's problems. And Augusta had a very strong proclivity toward doing class actions. We had that expertise. We'd been successful, and I think that because of that success, sometimes we were able to get compromises in cases that didn't require us to litigate them through trial.
You remember, for instance, Dan?
On a number of the jail cases, once we were able to get successful orders from judges, the next case, you negotiated the order, and there was a consent order. And sometimes you were able to get much greater relief for the client by negotiating that settlement. But it's like it is today. You have to know what you're doing, and your opponents have to know that you know what you're doing, and the judges have to know that you know what you're doing, and that we were able to establish that credibility, and that's something that we all really work toward and continue to work to preserve. Some of our newer people have the real benefit of going into courts where we've been really successful, and the judges really know that we know the law, and that when we try a case, we've got the law, and we are going to present our case in a way that hopefully will convince the judge or the jury to go our way. But that's come, I think, as we've been able to continue that hard work and reputation that Georgia Legal Services has. And I think when I started the class action work, because we were successful, that enabled us to then the next time negotiate a much better deal. And the jail cases are really good examples of that. We did that all over the state. After the Reidsville case, there were only a couple of cases that we actually had to do much trial work. Most of the other orders came at consent of the parties.
What were the particulars of the Reidsville case? What was the case, first of all?
That was a challenge to the conditions of the prison, the maximum security prison in Reidsville, and the NAACP Legal Defense Fund had been handling the case, and Judge Alimo asked Bob Cullen, who was then in Augusta, to come in as class counsel, and so he spent unbelievable amounts of time on litigating that case and developed an expertise that then he shared with others, and then we were able to bring other cases because we were seeing so many people from our communities being put in prisons and jails, and it's just the family members of our clients in other cases, and there were amazing conditions in these jails and at that point, and so we spent a lot of time on that, made some changes. I think that did change the conditions of for many inmates in the state.
So that was a case where the NAACP had filed a class action,
Right.
or the Inc. Fund, I
Inc.
guess.
Fund, right.
And then you got actually called in by Judge Alima.
Right. Right.
I just don't know exactly how it is, and pardon my ignorance, how the judge calls.
Well, the court is responsible for making sure that class counsel is competent and zealous, and a federal judge can decide that a person who purports to be class counsel is not adequate, or that you need additional counsel, and that's what happened in this case. That it was an enormous case with all sorts of issues, and there was just lots of work to be done. So brought in Bob Cullen.
Now you said you can't bring class action since anymore?
No, since 1996, the Congress decided that the Legal Services Corporation grantees, excuse me, cannot bring class actions or participate in class actions in any way. And in 1996, I was litigation director, and we had at least 20 cases that were class actions that were live, and then we had cases where, like some of these jail cases, where we were still monitoring consent orders, and we had to find other counsel in those cases and then seek to withdraw in them, and it's very difficult to do. After you've worked on cases, we were class counsel in the JR and JL versus Parham case that John Cromarty, our former executive director, argued in the U.S. Supreme Court, and I was involved with the case after it came back from the Supreme Court, and in our more recent actions for contempt against the state, and it was very difficult to withdraw from that case. We were representing a class of children who were in state custody, who were placed in mental hospitals, and our issue was getting those clients a due process review, in order to determine whether they needed to stay in the mental institution. And that case, you met just incredible children who'd been removed from their homes, sometimes when they weren't mentally ill, but there was something wrong at their house, and it seemed as though putting them in the mental hospital was safe. But it was very difficult to give up that case for me, because I've been so involved with the case in the last 10 years.
Can you elaborate on that a bit?
Well, what we were seeing is that children were placed in hospitals and kind of left there, and even though they were supposed to have a review every 90 days, for a variety of reasons, unless you asked for a hearing, there wasn't really much analysis of whether the child needed to stay in the hospital. And I just remember this one child who turned 5 in a mental hospital, and I thought, he'd already been in the hospital for a year. That was a large percentage of his life at that point, and he wasn't mentally ill that anyone could determine, but that seemed like the best place for him at the time. So luckily, that as we continued to work on this case, the state came to the realization and agreed with us that really they needed to focus on community-based programs for children, and that's been the focus. And so even though we didn't get a final resolution on our contempt motion, it's sometimes better to win that in a way where your opponent adopts your position, maybe not at your timetable, but will more willingly take action.
Can you remember, going through the year 1996 and sort of what not only you but legal services was experiencing as as you anticipated this, and then had to deal with this on a real.
Right. It was very difficult. It was very tumultuous around here, and many people were saying, well, if we can't do class actions, if we can't represent prisoners, because that's another group that we couldn't represent, I don't want to work here anymore. We won't be able to do anything. That class actions are what it's about. And because I was litigation director, I was on every one of those cases, and it was really going to impact what I was going to do and what we could think about doing for clients, and also thinking about, staff. If people came for the ability to work on a wide range of cases, and we've had cases from the administrative forums to several in the U.S. Supreme Court, including ones we've won. That's very difficult to then say, okay, well, you've got your hand tied behind your back because you can't do a class action. You can't seek attorney's fees, which often is a deterrent when you're dealing with an opposing party, that if they know that they're going to be paying your fees, you can be much more reasonable in a resolution or in the trial of the case. So when you have those two things happen, and then the prisoners, and because we did all this prison work, that was going to just cut out a whole area that we had been focusing on. And many people, said, well, I've got to leave. This is not for me, or, I don't know what we're going to do. And then we were faced with, okay, if we really got to do this, we tried to figure out how we could avoid it, but it was not going to be possible, that we had to get other counsel. And so I spent a lot of time talking to people, and, people would say to me, well, this is crazy. You can't get out of this case. You're class counsel. And I said, well, we're going to have to. So I've got to continue to try to find people. And luckily, we were able to get good replacement counsel in all cases. Though it was very depressing to think about. You're handing over this case that you've worked on for so many years, and that we knew that we wouldn't be filing anymore. And in some cases, a class action is really the only option for resolution of the issue, because it exists for such a short period of time for individuals that opposing counsel know that they can settle that one case, and then the issue is not decided, and then it's back for the next person. And so we can deal with those individuals, but what concerns us is the issue still exists, and what about all those people who don't come to see us? And there are so many people, especially in the more rural and remote areas, who never see an attorney. And so if we can't address things in a systemic way, it's going to cut back on the kind of relief that people can get. And that people will continue to be denied benefits, be evicted from their homes improperly, just a variety of issues.
Can I ask a question? Was the intention of the legislation to curb legal services activities? And reply to Cliff, if you would.
Yes, I think that legal services programs had been too successful and on a variety of issues, and that our opponents did not think that federally funded legal services attorneys should be out there suing governments or companies in class actions. And, just class actions in general have a bad name, though the class actions that we did were not for large sums of money. They were for injunctive relief, to make a government or a company do something or not do something, and also declare that their actions had been illegal, and get them to follow the law. But, it was part of what was happening in the country and in the Congress, and we've always had a lot of detractors, and so they felt as though that was one way to rein us in, and unfortunately Congress agreed. And
so which legislation is this passed by Congress? I mean, it's 96, you say, but it's specifically, do you remember the bill, or do you remember the...
Oh, I should, but I blocked it out of my mind.
That must have been kind of heartbreaking.
Yes.
As well as a political
right.
setback.
Right. It was very difficult to deal with. But in reality, and what I tried to keep telling myself and others, was that the person it really affected here was me, because I was the person who worked on all those cases. Other people worked on some of them, but some people didn't work on any of them. And so while it was a problem, and it still is a problem. It wasn't the end of the world, and so I had to deal with, and Phyllis too, trying to deal with, how do you reconcile with your senior lawyers who are doing this work and who are unhappy because they can't do it anymore with, there's lots of work that you can do and that we can't get so sidetracked that we can't do the significant work that is out there. Because I think since '96 we've been able to regroup and focus on lots of issues and new strategies for dealing with issues.
Such as?
I think working with community-based organizations, both in representing them as well as doing the community economic development work for them. That if there's a housing shortage, in the past we might have focused on handling a challenge to the eviction process. Well, maybe now we look at how can we build new housing? Can our community-based organization buy the housing? If it's in trouble, can they become the management company? Looking at different ways of addressing the same set of facts.
And there aren't restrictions on those kinds of activities?
No.
So you can actually, you can't form a community development corporation or foundation, can you?
We can represent community-based organizations, and we do.
You can represent, but you can't, initiate, those kinds of things, or you're not in the housing business per se.
No, but it's amazing how many organizations or individuals out there who want to create organizations are around Georgia, and I see that as really exciting for the future of our work because it's more of a community empowerment model versus the lawyer kind of directed kind of law practice. Excuse me.
Okay, well, let's talk about sort of how you got from the one model to the other model, because it couldn't have been sort of absolutely simple and direct.
Oh, definitely not. And we don't have a total community-based model now. We have a variety. I was just giving that as an example of something that we can do and do more of to replace some of the class action work. We've also beefed up our referrals to private attorneys to handle significant cases, and we can send cases to attorneys to bring class actions, and we'll continue to look at that. We've also looked at filing actions where a declaratory judgment is sufficient to strike down a particular practice or law and use that.
Sort of a class action.
Right, that there are some cases where that is possible. We have focused our attention more on litigating in the state courts and have been successful there on a number of issues. I think that our state constitution, as I said earlier, affords more rights, particularly in the due process area, than the federal constitution as it's being interpreted now in the federal courts, so that sometimes we filed cases in the state court, particularly in education context, to challenge expulsion, suspensions, for example, where that it's a state issue, and we've had some success there.
It seems that it kind of reversed almost 20 years of class actions.
Right. And that's sometimes when some of us old timers get together, we talk about, well, what were the cases that we used to do, and why were we successful then? Why does it seem so difficult now? Well, there's lots more law. There are many more cases been decided. There are some more pitfalls. In some other areas it's a little bit more straightforward. But law is constantly evolving, and I think that's the thing that keeps it really challenging, that you have to constantly think about, okay, well, if this avenue is foreclosed, how can we be thinking about using another strategy or another theory, or litigating in a different court to try to develop the law in a way that we think it should be developed, or to get courts to interpret the law in a way that's consistent with what we think the law is. That sometimes that takes a couple of steps before courts will agree with you. If they hear the argument enough, then sometimes they'll go along with you, but maybe not initially.
What happened to those children in mental institutions?
Well, I mean, some of them are still there. Many of the long-term hospital units that the state operated have been closed. Many more community-based placements and services for children. And, as I said, we didn't get a final order that said everything that we wanted to say, but I think that there have been significant changes, and that the work that we spent on children's mental health has been substantial over the years, but I do think that we had at least a part in making that better for children, and that there aren't so many children who are kept away from their families for so long and without the services that they need in order to be more successful at children and adults, which is certainly what we want for our children.
Now, I mean, you said just a minute ago that one of the interesting things about the law is that it always evolves and we're always working on new strategies. But I imagine, correct me if I'm wrong, that some of that's easier said than done when you're talking about convincing, say, some of these veteran lawyers who've been filing class actions for years, and this is what they really like and they could have, and so forth, to kind of, and again, sort of describe the process with some of these senior staff attorneys, some of the specialist attorneys and so forth who had been doing these kinds of class actions. What was the response?
Well, some people we were all angry.
Yeah.
Sometimes we just have these discussions like, well, what are we going to do? And people were very upset. It was, as I said, it was very tumultuous. People were, everyone was saying, well, I'm going to resign, I don't want to do this, I don't want to be part of this. But I think as we all start thinking about it, if we left, the other side wins. That if you stay or if you leave and support us by being a pro bono lawyer, or that you move on to being a judge or something else, as many of our alums have done, that we still have to figure out how to deal with the issues, that the client's problems haven't been solved, and that we finally came back to thinking, well, why we were really here was about clients. And some people did leave, but I think that the people who stayed and the people we've recruited since are really concerned about solving clients' problems. And it may be that it's more difficult in some ways because we don't have the class action or attorney's fees provisions out there to help us resolve clients' problems, but there are other ways that we can do things, and I think that it's made us more creative, and we work more in other ways. We participate more with other organizations. I think people are more involved with bar associations, trying to be leaders in other ways to get people to know about the issues that affect our clients, and hoping that they'll jump on the bandwagon and want to help us address some of those clients' problems. So, as I said, I think it's made us have to be more creative, and that's what's really fun. There's never a day that I think that I do anything that I did the day before, and there's always something new you've got to solve. And you mentioned earlier that it's hard to convince some judges. I mean, there are definitely some judges who don't want to believe that certain things are true, but one of the things that we really pride ourselves on is really knowing the law and being able to educate whoever the decision maker is about what the law is and how our facts fit into that law and why we should win. And there are some judges I know who say to our opposing counsel, well, this person is from Georgia Legal Services, so he really knows the law on this subject. So you better just, think about settling this case. And these are judges who a few years ago didn't want to believe that, a certain federal provision applied in your case.
Mm-hmm.
So I think that, hearing it enough, and that, you're always prepared, and that you've got some sympathetic situations with your clients, that you've got facts that support the resolution that you're advocating.
Be curious, the new recruits, obviously as your litigation strategies have evolved after 1996, for instance. That has implications for, the new recruits coming in. I'd be curious to compare, say, the recruits of 78 with the recruits of, say, 91 and the recruits of 2002 in terms of the people coming in, their characteristics, their training, their orientation, just kind of how new recruits come into the program.
I think in the late 70s, people were much more political. I mean, some of us had some familiarity with civil rights and maybe been involved with it, been much more political. And part of that was the reason why a number of people came to legal services. And so I think that kind of background made people be much more aggressive and also like suspicious of everything, that you questioned everything. And that's something that a lawyer who's left us but is now in private practice says, sometimes people in my firm just don't question anything. And he said that he's always got that in his mind because of working for legal services. And that's something that we try to instill in people. Just don't take things at face value. Just because someone says something's true, it might not be true. Or that someone says something is the law, look it up. It may not be what someone says it is. So that was our bent, and not everybody was as political as maybe some others, but people came with a lot of enthusiasm, and so it was very exciting. We were expanding. We had lots of lawyers, and we could do all sorts of things, and we were doing all sorts of things. As time went on, though, because we had cuts, that all during the Reagan years, President Reagan had Legal Services Corporation in at zero in the federal budget, and there were several years when we didn't know if we'd be funded for the next year, and we were having to make plans about what to do about getting rid of cases, how we would have other counsel take them, or whether you'd keep them on your own. So that was very challenging, and it was difficult to recruit people. And so by 91, I think there'd been some changes. There were some more people who were interested in legal services for justice reasons and not just because they wanted to help people. And so that people were...
Could you articulate the difference there?
I think that looking at justice really means how poor people fit into our overall justice system, and not just that you want to help some individual person on their individual problem, which I don't disparage at all. It's that I think that unless you look at legal services and being a lawyer as making the justice system work for everyone, and particularly our clients, and being willing to challenge judges when they don't follow the law, or that they have a practice that violates the law, to be willing to go to the judge and say, this is illegal and this is why. And some lawyers don't think about laws that way. It's more of, it's an occupation. But I think that really being a legal services lawyer is it's a calling, and that you have to really want to do it, because you don't get some of the rewards that you get as a private lawyer, or could get as a private lawyer. I think that now there are a larger number of people who are more concerned about justice issues, that they're kind of tides, and I think the national political scene has something to do with it. But also I think that the law schools have a greater number of maybe professors and administrators who are interested in justice issues. There are public interest organizations on campuses. Clinical programs are seeing more of a revival, and I see that as a really good trend, because once you've had a connection with a client in law school, pretty much whether you want to be a lawyer and deal with clients, or whether you want to be a lawyer and deal with companies, or use your law degree in a more non-traditional lawyering way. I think that with the good clinical training that some people have, it's really been much easier than when they come here, because they have a head start. At Antioch, we were able to work with clients for 3 years, and so by the time we arrived, we had that experience under our belts, and it wasn't intimidating to go to court. But if you're going to court for the first time as a lawyer, the standard is much higher than when you're a student going to court for the first time, when you have your supervisor always with you, and the judge is very happy to have you there as a student. So it's a different experience. But I think that the law schools are recognizing that they need to focus attention on lawyering skills, so that's benefited us. And also, as I said, the effort toward public interest is, and seeing more people who have a real interest in trying to deal with justice issues.
So your tasks now in 2015.
Let me just change the tape while
Okay.
we're right here.
Yeah, there are many more students, and some people have some really terrific experience when they get out of law school.
Okay, we're rolling.
So, compared to, say, when you took the job as litigation director in 91 compared to now, sort of how has your job evolved and how, your role evolved and so forth? Compared to, 11 years ago.
Right. Well, 11 years ago, I kind of acquired a lot of cases that we already had been litigating, so I had a ready-made set of cases to work on, the older class actions, and then we filed a lot of those, and so I was co-counsel on all those, and also our appeals. I think the thing that's constant is that we do a large number of appeals, particularly in the family law area. And one thing that I'm really proud of is that if you look at the evolution of law in family issues over the last 20 years, that our cases are very prominent in what the law is, and they're often cited in subsequent decisions. And so we have that history of being successful on cases that initially deal with our individual client's issue, but because we're looking at the overall state of the law also, sometimes the decision in our individual case benefits many other people.
Can you give some examples there?
What are the standards for removing children from their parents by the state when the state seeks custody, to articulate a clear standard, for example. We've been involved with various challenges to the third-party custody standard that the legislature passed several years ago, and wrote a number of briefs on that issue, and attempted to preserve the state of the law that existed before the legislation passed. That issue, we never received the specific ruling that we were advocating, though I think that the court did decide in a way that is reasonable to proceed for families.
Okay, well then, in what other ways has your own job
My own
evolved over the last 11 years?
Well, I think in recent years I've spent a lot more time on training and development of our newer lawyers, because in the past 5 years we've been able to hire larger numbers of new attorneys, and so we've spent a great deal of time training them. And one of the things that we developed was a new skills program for them, so that it didn't matter if you were in Dalton or in Savannah, that you would have this experience at having a mock deposition, doing a mock trial. We've had them do appellate briefs, and we have a whole continuum of what basic lawyering skills are, and that's something that I think has paid off with the experience of the attorneys. One of the things that I thought was great was after we did the deposition training one day, the next month I received court cost requests for depositions by people who'd been in that class. So I saw that they felt confident to do a deposition, and that they looked in their cases and found cases where they needed depositions and presented that to their managing attorneys for approval. So, that was empowering them to think about that particular way of obtaining information in a case through discovery.
What's the process for determining litigation, sort of the interaction between the specialists, you, people at the local level, and determining, litigation strategies and tactics and so forth. So what's sort of
The specialists are always trying to stay abreast of the developments of the law, both federal and state, so that they can be giving the local people information, and that's a large part of their job. We're also looking out at trends because we're talking to people all over the state. We know that there's an issue in one part of the state, there's probably an issue in another part, and we're trying to see, is it a statewide issue? Is it something that's just happening in one county? And then we constantly hear from staff about something that they would like to do. That if they see in one county or two counties in their region that the same thing's happening, maybe they get together with somebody else in their office and decide, well, let's really look at this, and then they'll contact the specialist, and we'll try to look at, is this something that can be dealt with on an individual basis? Is it so isolated, or is it something that's really much more significant and requires a different strategy? Then specialists will work with them, and we're talking and emailing now that we have email. I think we communicate a lot that way about what issues are. And if you've got a client where it looks like the way to address the issues through litigation, we put together a litigation team and analyze the law and the facts and discuss what the strategy should be. I think that's one of the things that we're really lucky that we have an experienced set of specialists, and that Phyllis and I have been here for a long time. We have lots of litigation experience that we can help the newer people think through how to address a client's problem or a group of clients' problems. And we like to have law students participate in that too, because they've got some new ideas. And I think that it's more of a collaborative effort, that I don't think that I can recall a case where, I've absolutely said, oh, we have to do it this way, or a specialist has said this, or, that a local person has said, well, the only way to deal with this is to file in X court under X theory. That we really approach it as a team effort, because there are lots of different things to think about in bringing cases. We don't have, in general, the kind of black and white cases. And that's what's fun is, how do you make the law? How can you put together an argument when it's not necessarily A to Z? And it's not something that's been done before. So we attempt to discuss, come up with the best strategies. We send around drafts. Again, communication by computers makes us all much more simple, because we're all spread out. That we don't have the proximity that sometimes makes it easier to address issues. But that's the way we've been doing it, and I think that's been our tradition at Georgia Legal Services, of collaborative effort of a local initiative supported by the specialist and litigation director.
Is this much the same, or is it different from when you were staff attorney in 1978 in the Augusta office?
I think that it's really quite similar, although I think that now, because we have, or it seems as though we have fewer resources, that I think we have more involvement at the central level earlier than I think we might have in the past. That I know when I filed that farmer's home rental case, that we had already done a lot of the development before we contacted anyone in Atlanta to discuss it.
And there's this feeling, correct me if I'm wrong, that the local people can do it too, or there was that we don't need Atlanta necessarily, right?
Well, I think that was true to some degree, though. We did certainly get help from specialists back in those days. I think perhaps now, because we have a lot of newer people, that maybe they do need the help of somebody, whether it's us. I mean, sometimes we get private attorneys to help, just help support what they're trying to do. Because there was that period of time in the 90s when we weren't filing things, we don't have the experience in our, under 5-year attorneys of federal court experience, for example. There are only a few people who filed cases, and I think now we're certainly back, and we've done it and been successful in a number of cases over the past year, but there was that period where we retrenched. We had smaller staff. We had to figure out how to solve problems, with all the turmoil, and it took a while to get back. But I'm really excited about the work that we've done over the past 2 years. I think that it demonstrates that people are thinking about how to solve problems in a creative way, and that we are filing lawsuits when that's necessary, and we have been successful in some different issues. I think that, again, we're working with the national support centers that were defunded by the Legal Services Corporation, and they've repackaged themselves.
Who are we talking about?
For example, the National Consumer Law Center, the National Senior Citizens Law Center, the Housing Law Project. They used to be federally funded, and then they were cut off too.
Oh, so they were funded through Legal Services Corporation?
Yes, that was their primary funder,
Okay.
and their objective was to support work around the country. And again, they were too successful, I think, and so that was cut off. And so those centers had to figure out a way to exist, and some of them charge for services. Many of them obtain attorney's fees, so that some of them live off of that, and grants and that sort of thing, so that it took a little while for them to get themselves back together. So there was this regrouping period. But I think that we've been able to capitalize on some of those reconstituted organizations for support for the work that we do. We filed an education challenge where we were, if not the first, one of the first programs to challenge a particular policy that the U.S. Department of Education had. And now our pleadings are being sought after by other attorneys around the country.
What was that case?
It dealt with discharging a federally insured student loan if the student became disabled after the person left school. And in our case, our client had HIV and had been quite ill and met the requirements, and we put the evidence before the agency, and the agency had some new policies that weren't ever promulgated by regulation, and we were attempting to challenge that policy. Often what we see is that what we're trying to do is make particularly governmental entities follow the law.
Let me ask about what seems to be perhaps a paradox, which is like you're saying if you get too successful, you get slammed, but you try to be successful. So, is there such a thing as being too successful or not? I mean, what's the balance? It's sort of an interesting kind of...
Right. Well, I think a really good example of us is, we used to be able to do lobbying in Congress and in the General Assembly. And in Georgia, we had been successful both on lobbying as well as in appellate decisions on consumer law. Our Georgia consumer law was very favorable to consumers, but we were too successful. So various owners of small loan companies went against us, and the law has changed, and we don't have a very positive set of consumer laws in Georgia, and that was partially because of success that we had. So that's a local example. It is a problem, but I think that it's critical that we continue to try to be as successful as we can for clients, and you have to look at lots of different forums. Legislative work is another thing that we're restricted from now. We can't do the affirmative kinds of lobbying that we used to be able to do. That cuts off a way that you can address clients' problems, because often a change in the law is the best thing that will happen. Though we can respond to legislators' written requests, and we do that and have been helpful in working on legislation that helps our clients. The most recent example is the unemployment bill that went into effect, addresses various issues that will help our clients, and one of our attorneys worked on that legislation.
It's interesting, though. Success each and every time almost has brought this kind of reaction, along with the successes and the enduring positive legacies, has also brought this kind of restrictions, reactions, budget cutting, and so forth and so on.
Well, exactly. Though, we have to continue to figure out, well, if you can't do this work with a certain kind of money, mainly the LSC money, we do have other sources of money, and sometimes LSC has not attempted to restrict all of the money. So, it's important for us to receive other funding so that we can do some of the other work.
Crucial in the history of the LSP is to kind of expand your funding sources.
Right, and
diversify.
also that by expanding your funding sources, you also expand the support that you get, and that it's somebody else's issue too, and not just this group of lawyers over here who really care about these issues. That it gets other people participating, and that's made it successful.
I want to go back to the Augusta office and just talk a little bit more about the history and some of the landmark cases that came out of that office. I'm interested in Buxton v. Lodge, or Lodge v. Rogers, I guess, which sort of, can you because really that I think still remains sort of the seminal voting rights case in the 1980s, if I'm not mistaken,
right.
The Supreme Court and all the rest.
Right.
Could you talk a little bit about the evolution of that case? I mean, I know you're not Bob Cullen and weren't intimately involved with it in the same degree, but you were in the office, et cetera.
Right. There were a number of amazing stories about what went on in Burke County and the level of racial discrimination and the evidence of it. The two water fountains with white and colored is an example. The whole structure of the county was so antiquated, and I know the lawyers felt evidenced strong racial discrimination against African Americans there, and so during the course of the litigation, there was all sorts of testimony about what happened and why it was discriminatory, and I know that the trial spanned days and days and days and days, and there was so much evidence, and the district court's order was pages and pages and pages long, and I think what I remember most about that case was that there was a lot of community sentiment about it. People were really concerned about how things were going to change, and that's what made people want to be involved with the case. And since the Supreme Court's decision in 1982, there have been significant changes in that county. That Herman Lodge, one of the plaintiffs, was a county commissioner. He was able to be elected, and he and others have been able to do some significant things in Burke County and address services for all people, including the African Americans who live in the community that didn't exist before. They've been able to have some development in the county that I don't know would have occurred if the voting rights case hadn't come out the way that it did. And while there are still issues there, I think that the case had a real impact on what people in the community thought could happen. And I think that's probably, for me, the most amazing part of the story, is that people had a feeling that they could make a change and that things could be better. And that on many levels, things are better there. There's still issues that they're working on, but, there have been improvements, especially in the quality of services, but that was really an issue for people. And people, African Americans have been elected, and they've got to be accountable to the public now. And I think that everybody has to pay more attention to being accountable, and I think that's important.
How was that sort of community hopefulness sort of manifested? What sort of expressions of that did you personally witness?
Well, we had opened an office in Waynesboro on the main street. I guess we did it in 1979, and it was a great community office because people came in there all the time. And so you had contact with community leaders and as well as potential clients, and it was kind of a meeting place. And so you were able to keep a good sense of what was going on in the community, what were the issues, what were people, what did they really care about. And I saw that when I would go down there, that there was a sense that things could change, things could be better, and they could move forward. And with my work in other counties around Augusta, I didn't see that. There are some counties that were back in a prior century in terms of race relations, for example, or forced governmental services. That the rich people didn't need those services, so that isn't what happened. But the other people did, and so until there was a change in the governmental structure, there weren't going to be changes that would benefit more people.
So what's the difference between Burke and some of the surrounding counties?
Well, I think that there was local leadership in Burke, and that they were willing to take on the power structure, and that there was the voting rights case against the county, which is the Rogers case, but there's also Rogers versus Lodge, and there's also a city voting rights case that impacted the.
Who was that?
I don't.
Donaldson? No, Donaldson.
No,
was Augusta.
that was Augusta.
Right.
I don't remember the plaintiff in that case. And then there was the school redistricting case in Burke County. So that we did 3 cases there, and the county commission case had the most impact, I think, and certainly is the most famous case. We did the same voting rights cases in Augusta, though I don't know that they had the same impact there, just because there's a lot of issues in Augusta that are not necessarily always related to race.
Right. I mean, the crux of the Burke County decision, as I recall it, was that the Supreme Court established that a pattern of discrimination rather than proven intent to discriminate was the basis by which you could order redistricting. Right?
Yes.
Let me be a devil's advocate and say, ask a question, what if there weren't like a power plant in Burke County? Would you have those services, or, what?
I think there'd be some level of services. You're absolutely right that the power plant gave them kind of the leeway to do a number of things that perhaps they would not have done otherwise. But I think that there would have had to be changes anyway. That when you have new leaders, they're going to have different priorities, and they were going to find a way to levy taxes on the farmers, for example. That if most of the land is owned by big landowners, that there has to be a change for the rest of the people.
And it's not only at the level of services, but also maybe if you could speak to the level of what you might call etiquette, in public meetings, or acknowledgement of certain constituencies. Maybe you could speak to that.
Well, I didn't personally observe that, though not in the county commission context.
Moving to another case, you mentioned Williams v. Butts. Could you talk about the evolution of that case, which also came out of the Augusta office?
Right. That was a case where our client had fallen behind on his mortgage, and
The farmers.
yes, and these are mortgages that only exist for housing in certain rural areas, and most of Georgia, it's possible to have one of these houses, and Georgia has non-judicial foreclosure for real property. And that means that all you have to get is a certified letter before your house is sold on the courthouse stairs. There are timings. The notice has to say certain things, but it's very minimal to take your home. And in our case, there were a number of errors in terms of what had happened in the calculations, in the money that the client owed and allegedly owed. And we were arguing that before the federal government could take one of these homes, that they had to go through federal court and file a federal action for foreclosure. And we were successful in getting an order that required that process, but also that before the Farmers Home Administration could attempt to foreclose, that they had to give a specific notice that said you have these rights to servicing, including interest credit, which reduces your mortgage payment for a period of time, or moratorium, which means you pay no mortgage payment under certain circumstances. And the real beauty about these homes is that it enables people who are the typical poor, working poor, who might lose their job, who might get injured, they might get ill for a period of time, they might have to take care of someone for a period of time, but their mortgage can be reduced to reflect what's actually happening in their lives in order to help them retain their homes. And it's been an incredible program in terms of preserving stable housing for people and families. And that's what we were trying to do in the case. And there was a significant order that required all sorts of protections for homeowners, and we litigated that case for a long time over what would remain in the order. The Farmers Home Administration came out with specific regulations that addressed the constitutional due process issues that we had raised, and the Farmers Home Administration went back to the federal court and said, okay, now we have all these constitutional protections by regulation. Please lift the order that says in Georgia we have to go through judicial foreclosure. And unfortunately, the judge agreed. We continue to do lots of work in this area because many of our clients, we've helped them get into rural housing houses, or they've already had them and they're trying to save them, and we've had to invoke the old Williams versus Butts orders. It's on our website. We all use it frequently to make sure that the Farmers Home Administration is following the requirements of the old notice, because that part of the order, the specific notice requirements, still exists. So
I hadn't realized that there was this kind of reversal at some point.
Yes. Just that took it out of judicial foreclosure in federal court. I at one point I had 10 of them, and trying to defend them in federal court was really much easier than if I had not had that option, where you can litigate and put on evidence that, what was going on with your client, what the administration had done improperly, how they violated the order, the regulation, the whatever, in order to save someone's house. That was a much better place to be than on the courthouse steps, or pre that trying to argue with the agency about how to save the person's home.
And then, as I recall, in the early 80s, sort of the backdrop to all of this is that it's impacting lots of people, in part because of the double-digit inflation,
right,
the issues that led to the tractorcade in Atlanta in '78,
right,
things like that. So,
right. That there were a number of issues, and as I said, earlier, the whole issue that when you're dealing with the government, that they have to give you notice that's adequate, and that you actually might know what it says or be able to understand it, and then that it tells you something that you can do so that you can be heard to challenge whatever the notice says. And the Williams versus Butts case is a good example of a due process case that came in because an individual had a problem, but we realized that lots of people had that problem, and having that order and still having the part of the order that requires the specific notice has enabled us to save a large number of homes, including just in the last few years where we've had to invoke that.
That original provision.
Yes.
Obviously, you love litigating. It seems that
Yes. Yes.
I do not like to face you in court, but as you're thinking about cases, which are there particular cases that strike you over the years as, ones that you've especially liked to have been involved with, both in preparation and in the actual litigation?
Well, I think that the work that we did in the last 10 years in the JR and JL case, I think was really important, and I was able to work with some incredible lawyers and some amazing clients, and some of the experts that we used was really an amazing experience, because there weren't easy answers on what we could ask the judge to do. There weren't easy ways to prove our case, because every child situation was different. And how do you decide which children you're going to use as witnesses, or which hospitals are you going to focus on? We don't want to exploit children, and certainly don't want to exploit clients in any way, but especially children, and children who've been labeled as mentally ill. How do you deal with that? And we had lots of discussions about how we would do it, and how we would approach the case. And every day when we were trying the contempt, we would go back to the Macon office, because it was in District Court in Macon, and the primary lawyers, Howard Sokol and Torrent Hogan, and I would have this discussion, but we'd bring in other people. Sometimes people would come for the day to help us. Our health lawyer, some law students, other specialists, other people in Macon would come in to help for a couple of days, and they would listen to us and say, y'all are crazy because you're just like so at each other. And we decided that we could just go at it every day, but that we'd leave that day with, okay, we've got the plan for the next day. And I think that it was very trying, but it was also very rewarding, because we were really trying to forge together a way to move forward on a case and be successful for those children. And as I said, none of us, we're not psychologists, we're not psychiatrists, there are all sorts of issues, but I think we thought through and, heard each other and, went forward in a way that hopefully helped get the state move toward the position that we were advocating. Another case that I worked on that I really found personally rewarding was representing a community association in Augusta, the Bethlehem Area Community Association, and I incorporated them and helped them obtain their tax-exempt status, and then they wanted to do all sorts of amazing things to try to better their community, and as their name implies. And they were an incredible group of people who really wanted to see their neighborhood improve. And it was an area that was totally black, very segregated area in Augusta. And anything that you did in that area was only going to benefit those people or other black people, because it was bordered by other primarily black areas. And the city was receiving large sums of community development block grant monies and was choosing to put the money in places that were benefiting other people. And back then the requirement was the principal benefit had to be for low and moderate income people. And, we didn't think that was happening. And a way to better this community was to get that money in that community. And so I worked with the group to educate them about what the community development block grant law was, what the possibilities were, what they could do with it, and they used that knowledge to try to argue for their position at the city council. Well, they originally came to us because they had tried to talk to the city council, and the city council some members had said, well, you can't speak unless you're a nonprofit organization, so that's why they had originally come to our office. So the next time they went back, they had some knowledge of this new law and that it should be coming to communities like theirs, and so they presented these lists of things they wanted to do, and city council just said no. So they continued to do that. We knew that there was a case being litigated in Alabama that addressed similar issues, and once the circuit court decided the case, we decided that we could file suit in our case to challenge the improper spending and racial discrimination in the funding and community development block grant in Augusta. And that case was extremely fact intense and went on for several years while we collected information through discovery and tried to put together a case. And that's a case that I lost, and I was very devastating, both professionally for me as well as for the clients. But what we all realized was that they had established themselves as major players, and that the city couldn't overlook them anymore. And since that time, there's been some progress, though recently there's been some setbacks. But in terms of the city deciding that the neighborhood is so decayed that they could just bulldoze parts of it. But the community association members were really incredibly devoted to improving things, and in a very unselfish way. They didn't have a personal reason other than they were living there, but many of these people were older, and so they were really looking at it as how to preserve this neighborhood for their children and grandchildren and others who wanted to live there, because it had a tradition of working people living in shotgun homes, and that it was a way to start being a home, as a homeowner.
Yeah.
And they wanted to preserve that opportunity for people. And, I personally learned a lot about, communities and working with community associations and just kind of the whole history of Augusta and about that particular community and the many fine people who came out of that community and went on usually in other parts of the country to be successful and to be leaders, and some of those people came back and they were able to make some changes in their communities, and then also because they had been working together so well, other individuals from other communities said, well, okay, you've got this community association going, will you come work with us? And so I thought it was really exciting to see that this group that I had the opportunity to work with at a very early stage was able to then branch out and help others and help them do some development work in their own community. So it was a really, really fun experience at working with people who had just an incredible amount of knowledge about the world and how they wanted to see their little part of the world in Augusta become better. And as I said, we weren't successful in the lawsuit, but at least for a period of time, they really did enjoy the fact that they were players and that the city couldn't overlook them anymore, and that their opinions had to be heard, and there were improvements in their community. And I think that that's a level of satisfaction that as a lawyer sometimes you don't get. But if you're only litigating because you're just looking for the next case, with this you're able to see that the community does make some changes for the better, and that's why I think that our working now more with community groups and on development work is a way to really improve communities and to help people in those communities have the skills, and then to be the brokers with whoever the decision makers are to help them get the money, usually the money that they need to take on their project.
Even though you might occasionally lose a case.
Oh, yes. I wouldn't like to think about, the number of cases that I've won and lost in my career. I think of more of it as, when you're successful, and particularly some of the successes that we've had at Georgia Legal Services, it's really quite astonishing when you think that we're really a fairly small group of lawyers and that we don't have all the money in the world. We often represent people who are really politically unpopular, but we can win major cases and win cases against governments as well as companies, sometimes against some of the best lawyers in the state. So that's something that I think we've been really lucky to have had those opportunities, because it would be easier just to handle individual cases. You asked about that earlier. It's easy just to take every case that comes, or not every, but most every case that comes in your office without thinking about, is this really going to benefit more people, or should I be doing something different to solve this problem? And as lawyers, most of us are trained to be litigators, and that's what we want to do. So it's, sometimes I have to resist the temptation to just say, okay, well, we can just keep litigating this issue over and over again. I mean, number one, that's not going to solve many people's problems because we don't have unlimited resources. Number two, lawyers will get bored with that. You don't want to keep doing the same thing every day. And number three, it does not change what happens. And we need to make sure that if it's the federal government agency doesn't follow the law, that it starts following the law. And we've certainly been able to do that in the past, and I think we will continue to do that in the future.
I'm going to ask one last question, which is, as you look back at now 20, almost a quarter century of
Yes.
Georgia Legal Services. Speak to some of the frustrations, but also some of the enduring accomplishments over that 24-year period of time.
I think one thing that's really frustrating is that even though I think that we have and continue to do a really good job for clients, that there is often an external climate that's very hostile to us and to our clients. It was more hostile when I first started. Some people in the local bar association called us communists and had all sorts of disparaging comments for us and wouldn't sit with us at bar meetings. That's certainly changed. But I think you still fight an uphill battle in some communities where you're taking on the power structure for someone who's poor and maybe a person of color, and that's still not popular. And that continues to be really frustrating because I don't think that the playing field in the justice system has been leveled. We've made a lot of progress, but there's still places in particular where there are really strong barriers that exist against our clients and against our advocacy, and so we have to continue to address those. And that's very frustrating because sometimes you don't have any control over what happens. I mean, you can only do the best job you can do every time, and that's our expectation. The whole idea of being so successful that it comes back to haunt you. That's something that you have to constantly live with. But again, we want to do what's best for our clients, and we have not backed down from things because it's not politically popular. That might have been easier, but it certainly was not the way to try to solve clients' problems, and we'll continue to do that. I mean, we're very tough on what it takes to file a lawsuit. We do a really rigorous review, but once we feel that we've got the law and facts, then we're going to do what we need to do for clients. I think some of what is really exciting now is that we have a real sense of commitment from staff. I think people are really concerned about...
Get back to where you just...
Right. Thinking about having the commitment of the staff and others. And as we get more people in the private bar who are interested in our issues, and I think we've done a lot of work in those areas, we have a lot more support. We can get more private attorneys to do cases for us or with us. Sometimes I just get people to review a particular case for me. That's often really useful, but that's something that didn't exist when I first started. Very few private attorneys wanted to talk to us about a case, much less take it on or co-counsel with us. So that I think that as we've expanded our willingness to partner with others, that's paid off for us, and I think that's really positive, that we're not just in it ourselves, and that I think that feeling that others want to be with you and fight with you is really exciting, because that definitely did not exist when I started. We were very isolated, and you felt like, okay, if you can't do it, then in Georgia Legal Services or perhaps help from Atlanta Legal Aid, we couldn't do it. But now I know that that's not true, and I think that's what helps us move forward. And we constantly have to be looking for new ways to solve problems, and reaching out to others is an important way.
Anything else you want to add? Or we can just call it a wrap right now?
I think that's it. I've been talking a lot.